Hello everyone, welcome back to Moving to Australia. I'm your co-host Arun Belur. I'm joined in the studio with Amitava Deb. Hi Amitava, how are you?
Hi Arun, good afternoon. I'm good. How are you?
I'm good. How's your health?
I'm still coughing, but I'll try not to cough during the discourse of this discussion.
Okay.
Let's see.
So we talk about health waivers today
Yes,
on our
we
podcast. So why would one need a health waiver and what's that all about?
That's because I'm coughing. I thought that this is an interesting topic that we should discuss. For any visa, well, not any, most of the permanent visas, there is a health requirement to be satisfied. As part of the process, the applicant and all the secondary applicants will have to undergo certain health checks. The outcome of the health check goes to the MOC. MOC means Medical Officer of the Commonwealth of Australia. The MOC will determine whether or not the applicant meets the health requirement. And if they find out that the applicant does not meet the health requirement, then they may refuse the visa.
Okay, you say may. It is not a certainty. So why would you say may refuse?
Why would I say, sorry, can you repeat?
Why would you say he may refuse the visa?
Oh, he may. That's because they have to then determine whether it whether it really fails the health test, or if it does, there is any provision for a waiver. If either of these are no, then the officer must refuse the visa.
Is a waiver available for all visa subclasses?
No, mostly visa subclasses which would cause considerable distress to an Australian or an Australian employer. So, which probably translates to partner visa. So, someone from Australia, an Australian citizen, is married to someone who is not Australian and has a health condition. However, not granting the visa would cause significant distress to the Australian person, which in turn will impact his work. Or it could be an Australian employer. So under these situations, there could be a health waiver available. Could be. It's not 100% that will be, could be.
Under what conditions would a health waiver not be exercised by the MOC, in your opinion?
So usually there are certain conditions which are known to definitely fail the health criteria. It's also clearly defined. The definition of failing or passing the health criteria is that the condition should not incur a cost of $51,000 over a certain period of time. That certain period of time is 5 years for someone who is below 75 years of age, and it is 3 years if someone is 75 years or older. So, if a hypothetical person who has a similar condition incurs cost which is equivalent to the amount I just mentioned, which is 51,000, then he is going to probably fail the health criteria.
Is that the only thing that they take into consideration before they exercise health waivers?
Or the health waiver, then comes the question of waiver. Waiver is only going to be available for partner visas, permanent partner visas, and employer nominated visas. Now, in doing so, the medical officer will inform the case officer. The case officer will make a written communication to the applicant to prepare a submission why the waiver should be exercised. The reason is they still have to demonstrate that despite having the condition, they are still going to be able to probably make contribution to Australia, and the cost of their treatment or the ongoing support and or medication is going to be less, or maybe significantly less than the contribution they will make to Australia.
Will an applicant need to apply for a health waiver?
Yeah, they can't apply on their own. They will be invited to comment if it seems that they will fail the health criteria. At that point, they will make the submission and they will provide documentation to prove that they must be granted the waiver, failing which it will cause undue distress to the Australian partner or to the Australian employer. Now, having said that, if both I'll give an example. If both the Australian partner and the foreign spouse, they are living overseas for a significant period of time, then it is unlikely that the waiver will be granted, because then the department will determine that they can actually continue their lives in that third country. So they have no need to come back to Australia. They would not have contributed so far to Australia anyway.
Okay. So you did mention that for every visa subclass there is a health requirement by the DHA.
Mm-hmm.
Now, only for certain visa subclasses there is a health waiver.
Yes.
Now, for those visa subclasses, are there any circumstances where the MOC might refuse to exercise the health waiver? What would those conditions be? When I say conditions, I mean what
the
would
health
be,
conditions.
Yeah. What would those health conditions be?
Significant physical impairment or significant intellectual impairment. So significant physical impairment could include blindness, for example, or someone has a physical disability that probably will impact their ability to work. Someone is on a wheelchair. Or intellectual impairment. For example, someone has a Down syndrome. So these are the two examples. Other examples would be HIV and hepatitis B, cancer. Although, even if someone had cancer and they have recovered, they might then consider that health waiver is not required and the person has recovered and may be granted the visa. Yeah.
So if one fails to meet the health requirement, what does one do next? Is their visa refused?
Okay, if the visa is refused even after they have made a submission, now there would be an appeal process. Appeal process is not available for everyone. It is only available for partner visa applications, regardless of whether the applicant is offshore or onshore, or it is available for those whose applications are made in Australia. So when an appeal is made, so usually when there is an application in progress, there is a bridging visa granted to the applicant. And if the visa is refused, then the bridging visa remains in effect for another 3 to 5 weeks, depending on the visa subclass applied for. And within this period, they must make an appeal to Administrative Appeals Tribunal, AAT. When AAT accepts the application, it goes into their file, then the bridging A visa continues. So they can continue to stay here. Now AAT is going to take quite a while unless there is a reason for prioritizing Usually it takes about 2 to 3 years. If AAT fails, AAT is an administrative step. After AAT is the judicial appeal. Judicial appeal is known as MRT, Migration Review Tribunal. If that one fails for another couple of years, then it will go for ministerial intervention. So there are few stages. However, in most cases, if for example, if it is partner visa, at AAT itself, it will probably be granted. It's unlikely that it will not go through after appeal.
So as you mentioned, this appeal could be a protracted affair. It can go on for months or years, depending upon how severe the case is. During this time, the applicant can stay in Australia on a bridging visa?
On the bridging visa, the applicant can stay, can have access to Medicare, can work.
Can work too.
It's just that the situation is quite uncertain. So it's not a good situation to be in. But at least there is a process, there is a solution. However, for skilled migration, you must understand that there is no provision for health waiver. So in a lot of cases, when people apply, and if one applicant is HIV positive, then the application will be refused. Now, in Australian visa system, there is a rule. The rule is known as one fail, all fail. So if in the visa application, one person has a health condition, the entire application will be refused.
Okay.
So I suggest that, if someone is worried that they may not meet the health condition because of an underlying illness, they should get themselves checked before making an investment for a visa application. However, a lot of people worry for small medical conditions like high blood pressure, obesity. One should not worry. These are not really the basis for visa rejection. A lot of people say, I can't sleep in the night. Will my visa be rejected? I said, no, not at all.
What if you have diabetes?
Diabetes depends on at what stage it is. At that point, and I think diabetes is a good question. It depends on the stage. The medical officer will then determine for that stage, a hypothetical person, how much cost will he incur over a period of 5 years. If it is more than 51,000, then yes, it may be refused. But it's all documented.
There's a lot of citizens and permanent residents who want to bring in their parents from back home. Now, if their parents fail to meet the health requirement test, is there any way they can appeal against that?
So there is no waiver for parents. There's no provision for a health waiver. But if the visa is refused on health grounds and they are onshore, then one can appeal to keep them.
And is it usually in favor of the applicant, the citizen or the permanent resident?
That's a big question. I'm not sure.
Because it could be the case that it's the only child who's living here, and then you have just one parent back home.
Those considerations do not matter. Unfortunately, the Department of Home Affairs is not a very humane department. For them, everything is black and white. Everything is documented and they follow the documentation process. But yes, if someone who has applied for a refugee visa, humanitarian visa, and has a health condition, there is a provision for waiver. But unfortunately for parents, there is no waiver provision.
That's really unfortunate. Anyway, thank you for your insight, Amitava. It was good talking to you. Thank you for all the information that you did provide. For those of you who are listening and you have still not subscribed to our podcast, please do so. You can get in touch with Amitava on LinkedIn, and the links to the website and Amitava's LinkedIn profile will be in the podcast description. Thank you for listening. Thank you for your time, and see you next week.
Yeah, thank you, Arun.
Bye.
Bye, everyone.